Now, subsequently, there was a revamp in the court structure in 1867, okay, especially of the judicial positions. There was a Privy Council, which is the Supreme Court of Strait Settlement. Okay, it was abolished the Court of Judicature of Penang, Singapore, and Malacca. Then you have Court of Quarter Session that handles all criminal cases. Recorder of the former courts became judges. Recorder of Penang became the Judge of Penang. And Recorder of Malacca and Singapore was appointed Chief Justice of the Strait Settlement. Right? So that is the revamp in relation to the judicial position. Okay? Under the court structure, there were some changes made. Now, the Court Ordinance of 1878, various courts were established. Subsequently, you have the Supreme Court of the Strait Settlement, courts of request at each of the settlements, magistrates' court at each of the settlements, coroner's court at each of the settlements, and a justice of peace. Okay, again, various courts were established. Okay, so you see, like today, if you look at our court structure, we have the magistrates' court, which is the lowest court, followed by sessions court, high court, court of appeal. Okay, formerly our federal court was known as Supreme Court, but now it is known as the federal court. So the court structure, how it took shape, okay, over time. Now, the Civil Law Ordinance 1878 came into force on the 1st January 1879. Under Section 6 of the Civil Law Ordinance, it allows for continuous reception of English commercial law into the Strait Settlement. Okay, so this allows English commercial laws to be applied in the courts. Now, there is subsequently modification of English laws, okay, taking into consideration the local custom, where the Court of Judicature established in the Strait Settlements were to administer the principles of common law and equity, which were then in force in England as far as the local customs will admit. Okay, there is no need for modification, and English law cannot be accepted in totality. If you look at the case of Kulas and Coulson, where Recorder Maxwell said, it has been repeatedly laid down as the doctrine of our law that its rules are not applicable to such races when intolerable injustice and oppression would be the consequence of their application. Okay? So if local customs do not allow for the application of English law, okay, so you don't accept English law in totality, that's what it means. In the case of Yok Chen Neo and Ong Cheng Neo, okay, the pre-council said, in applying this general principle, it has been held that statutes relating to matters peculiar to the local condition of England and which are not adapted to the circumstances of the colony do not become a part of its law, although the general law of England may be introduced into it. Okay, so what it means is local customs to a great extent will be taken into considerations, okay, when they are applying English law in deciding cases. So the Royal Charter of Justice 1807 provides that so far as the local circumstances will admit, so far as local conditions and inhabitants will admit, so far as the several religion, manner, and customs of the inhabitants will admit. Okay, so such modifications were primarily in family law and related subject matters such as marriage, divorce, adoption, and succession. Okay, so local laws will also be considered, okay, when they are deciding cases. So these are some local circumstances that were considered, okay, in applying when the courts were deciding these cases. Please look up the 6 widows case. Okay, this was in relation to Chinese polygamous marriages were recognized. so as to allow secondary wives and their children to be provided for under the statute of distribution. In Sharif and Michel, Malay custom on acquiring ownership of land was recognized. Okay, and Kulas and Carlson was recognized that a married Muslim woman had the capacity to enter into contract in her own name. So they do consider the local customs and traditions, okay, in applying English law, okay, with modification. So these are some cases that you can look up in Goods of Abdullah's case, Fatima and Logan, Ong Chien Nyo and Yop Chien No, okay, to what extent, okay, English common law is applied and to what extent modification can be done, okay, in deciding local cases. So that is the first stage of British influence in Malaya, which is the Strait Settlement. So you need to know how British made their presence in Penang, Singapore, as well as Malacca, and how the Strait Settlement was subsequently formed in 1826. What were the changes in the legal system that was brought about by British intervention in these three states? Okay, under the first Royal Charter of Justice, the second Royal Charter of Justice, as well as the third Royal Charter of Justice. So the second stage, okay, will be the Malay states. The second stage of British interference is in the Malay states. Now, while the Strait Settlement, Penang, Malacca, and Singapore were colonies and under the direct British rule, we find that the rest of the Malay states were ruled by sultans. And each of these states, you see, they were embroiled in various succession disputes. And as a result, British interfered in the succession dispute, and in return for British interference, the sultans had to appoint residents in these Malay states. So the Malay states are divided into federated Malay states. So if you look at those in yellow, states in yellow, we looked at it earlier, Perak, Selangor, Negeri Sembilan, and Pahang. Those are the federated Malay states. And those in green color, which is Perlis, Kedah, Kelantan, Terengganu, and Johor, are the unfederated Malay states. So what was the applicable law before British intervention in the Malay states? Now, in the case of Sheikh Abdul Latif and Sheikh Ilyas Bats, Edmonds, he said that before the first treaty, the Pangkor Treaty 1874, the population of these states consisted solely of Mohammedan Malays, with a large industrial and mining Chinese community in their midst. The only laws at that time applicable to Malays was Mohammedan modified by local custom. So when you talk about Mohammedan law, it's Islamic laws. In the case of Ramah and Latun, Justice Thorne said to the effect that Muslim law is not foreign law, it is a law of the land, and the local law is a matter of which the court must take judicial notice. Okay, so you find that Islamic law has been practiced in these states, okay, when British made their presence. So let's look at British intervention into the Federated Malay States? What were the disputes that were happening in these states? The first state is Perak. Now, in 1873, the Sultan of Perak, at that time, Raja Ali, passed away, and a succession tussle occurred as to who will become the new Sultan of Perak. There were two people, which is Raja Abdullah or Raja Ismail, okay, who were fighting for the throne. Now, British supported Raja Abdullah, and as a result, he became the Sultan of Perak, and in return, a British resident was appointed, and the first resident of Perak is J.W.W. Birch. Now, in Selangor, there were many problems, okay, mainly piracy, and also a civil law was happening in Klang. And in 1875, British forced Sultan Abdul Samad, okay, the Sultan of Klang at that point of time, okay, in Selangor, to sign an agreement which included the appointment of a British resident, okay, in return for resolving the dispute. Hence, the first British resident in Selangor was J.G. Davidson. Now, likewise, in Pahang, also there was a civil dispute. In 1888, a British shopkeeper was murdered near the Sultan's palace, and British used this issue to compel the Sultan to accept a British resident. And the first British resident in Pahang is J.P. Roger. And the last state, the next state, we have got another state as well, which is Pahang, Negeri Sembilan. In 1872, the ruler of Negeri Sembilan, Datuk Kelana Siding, dies. And as a result, the state was divided into two and ruled by two Malay chiefs, which is Datuk Kelana Syed Abdul Rahman and Datuk Bandar Kulub Tunggal. Now, British supported Datuk Kelana Syed Abdul Rahman, and as a result, in 1889, Martin Lister was appointed the British president. Okay, so that was British interference in the four federated Malay states. So we looked at Perak, Selangor, Negeri Sembilan, and Pahang. So in 1895, the Treaty of Federation, okay, was signed, where the four states, Perak, Selangor, Negeri Sembilan, and Pahang, became protected states, or commonly known as Federated Malay States. And all four residents were placed under a resident general who was made accountable to the governor of the Straits Settlement. Okay, so that's how the Federated Malay States was formed. Okay, you find that in each of these states there was some conflict, dispute. British made their presence, they supported, okay, one of the parties, and as a result, the sultans had to appoint a resident. Okay, so indirectly you find that the residents, okay, they are the ones who have powers. The sultans are akin to puppets. Okay, so the residents are the ones who control and dictate to the sultan. So let's look at the outcome of British colonization in the Federated Malay States. Okay, so the sultans accepted a British resident whose advice had to be asked and acted upon in all matters, except matters in relation to Malay religion and custom. Okay, so the residents had a lot of powers over the sultans. Now, as advisors, the residents introduced many British Indian statutes into the Federated Malay States, the Penal Code, the Contract Ordinance, Criminal Procedure Code, Civil Procedure Code were all introduced. And subsequently, courts were also established and judges were appointed in the Federated Malay States. Now, rulers were retained as sovereigns, but actual power was in the hands of the resident, as I mentioned earlier. Now, subsequently, the Civil Law Enactment 1937, was introduced. So English law was formally introduced into the Federated Malay States. Pursuant to Section 2 of the 1937 Civil Law Enactment provides, so save so far as other provisions has been made or may hereafter be made by any written law in force in the Federated Malay States, the common law of England and the rules of equity as administered in England at the commencement of this enactment shall be enforced in the Federated Malay States. Okay, so that's how the common law was subsequently introduced into the Federated Malay States by the Civil Law Enactment of 1937. So what is the effect of the CLE 1937? English common law and rules of equity became the governing law in civil, commercial, criminal matters, replacing custom and religious law. Okay, so local laws was limited to personal matters, namely family matters and inheritance. So the next Malay state is the unfederated Malay states. Okay, unfederated Malay states are those states in pink, we looked at it earlier, which is Perlis, Kedah, Kelantan, Terengganu, and Johor. Now, these states were under the rule of Siam. Siam is the old name for Thailand. So, the Bangkok Treaty 1909, a treaty between the United Kingdom of Great Britain and Ireland and the Kingdom of Siam was entered into. And with that treaty, Siam surrendered their claims to the 5 states to British. Okay, so British advisors were appointed in each state, and the law administered was Islamic laws and Malay customary laws were also practiced. British established courts and appointed judges, and British Indian statutes were also applied. Okay, because you find that prior to Malaya, British also colonized India. So a lot of our statutes, okay, the Evidence Act, Contracts Act, the Civil Procedure Code, okay, it's all mirrors the Indian enactments and statutes, okay, which was introduced into Malaya. So they are applied in Malaya by the British. So the formal reception of English law, okay, in the States, in 1951, the Civil Law Extension Ordinance was introduced. Okay, this ordinance provides that by virtue of Section 2 of the Civil Law Enactment 1937, is hereby extended to apply to the states of Johor, Kedah, Perlis, Kelantan, and Terengganu. So that is the second stage of British influence in the Malay state. So you need to know how they make their presence in the federated Malay states as well as the unfederated Malay states. Now the third intervention is in Sabah and Sarawak. The old name for Sabah is North Borneo. Okay, and Sabah and Sarawak at one point of time, they were part of Brunei. So let's see how British made their presence in Sabah and Sarawak. In 1839, James Brooke came to Sarawak. There were internal problems, and Raja Muda Hashim offered him the position of governor of Sarawak in return for controlling a civil war. So just like in the federated Malay state, you find that their British influence in Sabah and Sarawak is also due to some conflicts or disputes, internal disputes occurring within the states. So Brooke's main challenge was to restore law and order in Sarawak and to provide proper administration and to suppress piracy, which he succeeded. So subsequently, in 1841, James Brooke became the governor of Sarawak, and a set of 8 laws on criminal matters, mainly trade, labor, collection of state revenue, were introduced and subsequently codified. Okay, customs of local inhabitants were retained as far as possible, so they respected the customary laws. All right, and there was also frequent consultation with native chiefs. Okay, so they had a cordial relationship. These are some of the rulers of Sarawak, also known as the White Rajas of Sarawak. 1841 to 1869 was James Brooke, 1868 to 1917 Charles Brooke, and 1917 to 1941 Charles Rainier Brooke. So what about the reception of English law in Sarawak? Okay, the law of Sarawak Ordinance 1928 provides the law of England insofar as it is not modified by orders or other enactments issued by His Highnesses the Raja of Sarawak or with his advice, and insofar as it is applicable to Sarawak, having regard to the native customs and local conditions, shall be the law of Sarawak. So that's how the British common law was introduced into Sarawak by the Sarawak Ordinance 1928. Okay. Subsequently, the Sarawak Application of Law Ordinance 1949 was introduced, okay, where the Common Law of England Doctrine of Equity, together with statutes of general application as administered or enforced in England at the commencement of this ordinance, shall be enforced in Sarawak. Now, Sabah subsequently was also colonized by British, okay, formerly also known as North Borneo. It was administered by Sultans of Brunei and Sulu. Okay, if you look at the maps there, okay, you will see Sabah. Okay, the British North Borneo Company was formed in 1881, based in Sandakan, and was granted concession to much of North Borneo in 1865. Right, so it was also a trading port. In 1881, Sabah was placed under the administration of the North Borneo Company, and in 1888, the governor of the Strait Settlement became the High Commissioner of Brunei, Sabah, and Sarawak. British subsequently introduced the courts, appointed judges, and enacted laws in Sabah. So between 1881 and 1902, various laws were enacted. Okay, Native Rights to Land Proclamation, 1889, the Abolition of Coal Tax Proclamation, 1902, the Village Administration Proclamation, and many others. Okay, so that's British intervention in Sabah. So the formal reception of English law was introduced in Sabah by the Civil Law Ordinance 1938, okay, which is similar to the Law of Sarawak Ordinance 1928. Okay, in 1951, the CLA 1938 was abolished and replaced with the Application of Law Ordinance 1951, which was similar to the Application of Law Ordinance 1949 of Sarawak. Okay. So the Federated Malay State, okay, subsequently you will see the Civil Law Enactment 1937. The unfederated Malay states, you had the Civil Law Extension Ordinance 1951, were abolished upon the formation of the Federation of Malaya and replaced by the Civil Law Ordinance 1956, which subsequently becomes the Civil Law Act 1956, okay, where pursuant to Section 3, the reception of English law is okay, allowed, provided we do not have any local statutes on the similar subject matter. So when Malaysia was formed, there were 3 separate statutes authorizing the application of English law. Okay, to follow the trend that we looked at the different states, we had the Civil Law Ordinance 1956 in West Malaysia, North Borneo Application of Law Ordinance 1951, have the Sarawak Application of Law Ordinance 1949. So we had 3 different laws that were applicable. And after the formation of Malaysia in September 1963, the Civil Law Ordinance 1956 was extended to Sabah and Sarawak. So you have the Civil Law Ordinance 1956, which applies to all the 11 states in the Malaysian Federation, and subsequently the Civil Law Act 1956 that was revised in 1972 did replace the 56 Ordinance when Malaysia was established in 1963 to standardize the laws to include Sabah and Sarawak. That's how the CLA 1956. Okay, you need to know how the laws were enacted as a result of British interference in Malaya. Okay, so you can look at all this: the Civil Law Enactment 37, Civil Law Extension Ordinance 51, Civil Law Ordinance 1956, and the Civil Law Act 1956, which was revised in 72. Okay, you can look at how the laws were enacted. Okay, so next, what do you understand by the term legal pluralism? Does legal pluralism exist in Malaysia? Okay, when we talk about legal pluralism, is the interaction between 2 or more laws within the national legal system. So when we looked at the development of the Malaysian legal system, we looked at starting, we have various customs that was practiced, or adat. Okay, you had customary laws, okay, you have the Islamic laws. At the same time also you had the Chinese and Indians who brought their customs and tradition. Okay, we also looked at adat. We had the Adat Temenggung and Adat Kerpatih. Okay, subsequently you find that we also have the Islamic laws where the Sharia courts deal with Muslim laws, right? That provides uniformity between laws in Peninsular Malaysia, Sabah and Sarawak. So just go through all the different stages of customs, tradition, okay, the adats that were practiced in Malaya, and look at how our legal system came about, okay, with the British influence in Malaya. Alright, so these are the various categories of customary laws that we had looked at, Malay customary laws. We also have the native customary laws applicable to non-Malay natives, which is Chinese and Indians. Then in Sarawak, you also have Chinese customary laws. You have Chinese and Hindu customary laws. Okay, so this is why you find that there is legal pluralism in Malaysia because of the various ethnicities that ethnics and religious groups that reside in Malaysia. So there is to a great extent legal pluralism in Malaysia. So with that, okay, we've gone through the historical background of Malaya. We looked at the influence, okay, the various superpowers that have colonized Malaysia at one point of time. We started off by looking at the Malacca Sultanate, okay, and then we looked at the Portuguese influence in the Malacca Sultanate, Dutch influence, and the British influence is the landmark where they ruled Malaya for a very long time, almost 150 years. So when you're looking at the British colonization of Malaya, you need to be familiar with the three stages. Okay, this is a very popular question for exam normally. You need to be familiar with the Strait settlement, how they ruled Penang, Singapore, and Malacca, and how the legal system, the common law, was introduced, and then British influence in the Malay states, federated and unfederated Malay states, as well as East Malaysia, Sabah, and Sarawak. So this is a past year question, a classroom activity for you to do in your own time. To what extent the British colonize shaped the legal system of Malaysia? Explain the reference to the three stages of British intervention in Malaya. So for your exam, you will not be asked all the three stages. You may be asked just probably one or two stages. But it's good for you in your revision to clearly understand all the three stages of British intervention. Okay, so thank you.